I am Phil Flakes, the co-founder at Succession Link, and will be the moderator for today's webinar. So with just over 8,000 registered users, Succession Link is the leading networking and communication platform for financial advisors looking to buy, sell, merge, and find succession options for financial advisory practices. As a platform, we look to provide resources, data, and educational content, and today's webinar is a great example of the type of content we like to bring to the entire Succession Link community. So before we get started, there are a few quick housekeeping items to mention. First, this webinar will be recorded, and it will be distributed by email to all attendees. It will also be available on demand through our Succession Link YouTube page, and there you can find all past webinars and podcasts. Second, the slide presentation is available for download on the right-hand side of your screen in the GoToWebinar window, but it is also going to be distributed by email after the presentation. And finally, for those of you who asked questions during the registration process, we certainly appreciate those questions, and we will look to address as many of those throughout the course of the presentation as we possibly can. So today's webinar, titled Buying and Selling Financial Advisory Practices, an Overview of Legal Issues. I'm joined today by three partners with Ackerman LLP, and Ackerman as a whole is a leading transactions and trial law firm known for its core strengths in middle market M&A within the financial services and real estate industries. With more than 600 lawyers and government affairs professionals and a network of 20 offices, Ackerman is ranked among the top 100 law firms in the United States by the American Lawyer, and they're also recognized as a leading law firm by Chambers and the Legal 500. Joining me today, we have Lorenzo Borgiorni. Lorenzo is a New York-based partner with over 20 years of experience representing companies in mergers and acquisitions and securities transactions. He has structured, negotiated, and completed more than $40 billion worth of M&A transactions for deal principals, including funds and strategic buyers and financial advisors. His recent experience includes representing RCS Capital Corporation in connection with numerous public and private acquisitions of broker-dealers and registered investment advisors, including Summit Financial Services Group, Investors Capital Holdings, J.P. Turner, VSR Group, and Gerard Securities. Also joining the panel today is Jack Habert. Jack is also a partner based in New York, and he concentrates his practice on negotiating and documenting structured finance and complex derivative transactions and the regulatory analysis of securities, commodities, and insolvency issues related to such transactions. Jack advises major financial institutions, investment advisors, hedge funds, mutual funds, and other corporate entities as either providers or end users of such transactions. From September of 2010 through January of 2012, Jack also served as an attorney fellow at the SEC in the Division of Trading and Markets, advising on rules and implementing various provisions of the Dodd-Frank Wall Street Reform Act. And last but certainly not least, we have Michael Kelly joining the panel as well. And Michael is a partner with Ackerman based in Washington, D.C., and he focuses his practice on U.S. and international private equity and mezzanine investment funds, venture capital funds, hedge funds, and impact investing funds. Michael has nearly 20 years of experience in the formation, structuring, and issuance of securities by investment funds. He also advised and lectured on regulatory, compliance, and government matters relating to investment funds industry. He has been involved in numerous mergers and acquisition transactions involving investment advisors as both in-house and outside counsel. Gentlemen, thank you for joining today and welcome.
Thank you, Phil. Good afternoon, everyone. This is Lorenzo Borgiorni. Today, we will provide an overview of the legal issues faced by investment advisors when buying and selling their investment advisory practices. Michael will first walk us through the basic features of the regulatory regime as they impact deal structuring and execution. I will then outline some of the rationales underlying M&A transactions involving advisors and provide some recent data on deal activity and trends. Next, I will provide a high-level overview of a typical M&A transaction involving an advisor. We will then go back and address in more detail some of those typical steps, including diligence, transaction documentation, closing conditions, and regulatory approvals. But we'll finally opening up for questions. Michael will now walk us through the first couple of slides. Michael?
Great. Thank you very much, Lorenzo. Good afternoon to everyone. My name is Michael Kelly. The Investment Advisors Act of 1940, as modified more recently by the Dodd-Frank Wall Street Reform and Consumer Protection Act, is a very expansive topic and impossible to cover just in a few minutes here. However, we want to focus on a few key areas and key elements of the Act, especially for those of you who are currently exempt reporting advisors who may be contemplating acquiring a registered investment advisor, or those of you who may be exempt reporting advisors contemplating a business combination that following the closing of that combination would be subject to becoming a registered investment advisor under the Act. First of all, a few basics. What is an investment advisor? The definition of investment advisor is very broad, encompassing anyone who is in the regular and continuous business of advising others or issuing reports or analyses regarding securities for compensation. The key words there are regular and continuous business, securities for compensation. Typically, an investment advisor does not include family offices, service providers such as lawyers, accountants, and real estate agents, nationally recognized statistical rating agencies, or bank holding companies. A firm that falls within the definition of investment advisor must register with the SEC under the Act unless it is prohibited from doing so because it is a smaller firm regulated by one or more states, or if not so prohibited, it qualifies for an exemption from registration under the Act. In 2011, the SEC adopted rules implementing new policies and rules governing investment advisors, which became effective the following year. Specifically, for advisors with less than $25 million in assets under management, they are considered to be small for these purposes and therefore generally prohibited from registering with the SEC. Notable exceptions to this threshold include advisors to public mutual funds, that is, those investment companies who are registered under the Investment Company Act of 1940, or business development companies. Also exempted are multi-state advisors or internet advisors. At the other end of the spectrum are large advisors with at least $100 million in assets under management, which are required to register with the SEC unless exempted. Some of the key exemptions, and some of them which you may be most familiar with, are the private fund advisor exemption, which generally applies to advisors to private funds that have less than $150 million in assets under management. Another exemption is the venture capital fund exemption for advisors who advise solely one or more venture capital funds. As I mentioned before, family offices are also subject to an exemption, as are certain foreign private advisors, if they meet the 4 or 5 criteria for taking advantage of that exemption. For all of mid-sized advisors, it really depends. Generally, investment advisors that fall between the 25 million and a 100 million thresholds are subject to state regulation if they are actually registered in the state and are subject to examination by the applicable state securities authorities. Otherwise, they must register with the SEC. In addition, the Act is modified by the Dodd-Frank Act also provides for a buffer zone, generally between 90 and 110 million. So you are, as soon as you reach the 100 million threshold, you are permitted to register, and you're allowed to remain registered until you fall below 90 million assets under management. Generally, SEC registration preempts the application of state investment advisor statutes. The Advisors Act imposes 5 types of requirements on registered investment advisors. First, and probably most importantly, are the fiduciary duties, which require the advisor to act in the best interest of clients. I'll be discussing this a little bit more later in the presentation, as this appears to be a key area of focus for the SEC in its audit of registered investment advisors. In addition to the fiduciary duties, the Act provides certain requirements for substantive prohibitions and requirements, certain contractual requirements, record-keeping requirements, as well as generally for administrative oversight by the SEC, primarily by inspection and audit. All of these requirements are very relevant when performing due diligence on a target for acquisition, as well as for drafting the purchase agreement, reps, and warranties. All investment advisors, registered and not registered with the SEC, are subject to the anti-fraud provisions of the Act. Whether and how a registered investment advisor has addressed its fiduciary responsibilities is a key element of the SEC audit process. Additional layers of regulation may derive from the registered investment advisor being affiliated or associated with other regulated entities. If that is the case, as we will see later in the presentation, additional layers of regulation apply, which may significantly impact the structure and timing of a transaction. And finally, although registered investment advisors are not regulated by FINRA, FINRA does operate the Investment Advisor Registration Depository for the electronic filing of Form ADV. I'm now going to turn back to Lorenzo, who will discuss the mergers and acquisitions trends and business rationale.
Thank you, Michael. According to the IRA Deal Book, which tracks M&A transactions involving the approximately 4,200 registered investment advisors that have over $100 million in AUM, 2015 set a new record for M&A activity among IRAs. There were 123 transactions completed in 2015, compared to 90 in 2014 and 58 in 2013. Given the highly fragmented status of the industry, this trend is expected to continue and potentially accelerate over the next 5 to 7 years. Consider that if there are 4,200 participants and 123 transactions, that is only approximately 3% of the participants that were involved in M&A transactions. Typical rationales underlying M&A transactions involving investment advisors include to effect a succession of ownership, to achieve diversification, gain access to a new market, or acquire new skills or capabilities. The recent example of this is the announcement early this month by Ally Financial, formerly GMAC, that it was expanding its financial service offerings by agreeing to acquire Trade King Group, an online broker-dealer for self-directed investors and a provider of a robo-investing platform. Other rationales are to realize synergies and benefits of scale. This is a customary reason for engaging in an M&A transaction, but perhaps it shouldn't be the main reason, and those opportunities should be carefully scrutinized beforehand to make sure they're actually available. You can also do a deal for regulatory reasons, such as buying an investment advisor who's already registered, thereby avoiding the cost and burden of registration from scratch. Phil, can you just move to slide 11? We're going to now go through the typical steps in effecting an M&A transaction involving an investment advisor. The first step for the participants is to hire advisors, financial, accounting, tax, and legal. Clients may hesitate to bring advisors on board early on in the process to keep expenses in check. The advisor can help clients assess the feasibility of the transaction from a legal, financial, and tax standpoint before the parties reach an understanding on major deal terms, which should help significantly streamline the process down the line. The first document to be executed by the parties is the confidentiality agreement, which allows the buyer and its advisors to begin diligence on the seller and its business. As the parties reach a basic understanding of major deal terms, they may want to memorialize that in a term sheet or non-binding letter of intent. Those terms may include deal structure, price or a price formula, form and timing of payment of the consideration, price adjustments, indemnification terms, closing conditions, and ancillary arrangements including management, employee benefits, and governance. While putting together a term sheet or other non-binding letter of intent is not required, we find that it greatly focuses the parties, thereby accelerating the process and making it more efficient. Some of those terms may be binding. For example, the buyer may insist on seller agreeing to some period of exclusivity. And the parties may agree on allocation of fees and expenses that is other than each party pays its own. In that case, the parties should be careful about specifying what is binding and what is not. Michael will discuss more in detail the diligence of the seller and its business by the buyer. I will just mention here that if any part of the consideration in a transaction is stock or other securities of the buyer, the seller may also want to perform diligence on the buyer and get some business reps from the buyer. This is more likely to happen if the buyer is a publicly traded company, in which case the seller will be able to rely in large part on the buyer's public SEC filings. The preparation and negotiation of the transaction documentation generally goes in parallel with the diligence review of the seller and its business. the buyer takes the lead in drafting the transaction documentation, purchase agreement, and ancillary agreements, whereas seller will have principal responsibility for preparing the disclosure schedule for the purchase agreement and any required regulatory filings. As far as execution of the purchase agreement, there could be a situation in an M&A transaction where no regulatory approvals and material third-party consents are contemplated, and therefore the parties can simultaneously sign and close the transaction under the purchase agreement. That scenario is highly unlikely, if at all possible, in an investment advisor context because of the need to obtain client consent to the assignment of the advisory contracts under the Investment Advisors Act and possibly under the contracts themselves. So normally, there is a gap between sign and close, which results in an additional layer of contractual provisions intended to govern the rights and obligations of the parties through the dependency of the transaction, as well as their commitment to consummate the transaction. The closing occurs when all applicable consents and approvals have been obtained, and thus all closing condition precedents to the closing will be satisfied. But closing the deal hardly means completing the transaction because, as we'll discuss later, much of the times only part of the consideration is paid at the closing, and often not even the majority of it. After the closing, the lawyers get largely out of the picture, but for the buyer, most of the work lies ahead, as it will have to integrate the target and its employees into its own organization. We will now go back and review in more detail some of those typical steps, beginning with due diligence. Michael?
Thank you, Lorenzo. When undertaking due diligence on a seller, the buyer is looking to answer two fundamental questions. First, is the acquisition accretive to my existing business without imposing undue risks? And two, assuming the answer to question number one is positive, then how do I structure the acquisition to maximize return and minimize risks? Generally, in the process of performing due diligence, the buyer will generally take the lead with its advisors. However, the seller, who may be motivated, may ready itself for a sale and thus not only reduce the buyer's burden, but also shorten rather significantly the transaction's timeline. The seller can hire consultants to advise on best practices, draw up a due diligence request list, and set up a virtual data room and perform a mock-up audit of the investment advisor, all to assist the buying process. The purpose and scope of due diligence is aimed at verifying the target's past performance, mainly revenue and profit, and probing its future prospects, while identifying possible issues, legal and non-legal, and all this factors into determination of the purchase price. The main areas to review in the due diligence process are grouped generally into three. First of all, business and financial. As part of the business and financial due diligence, you want to take a look at revenue sources. What about assets under management, advisory fees, management fees, performance fees, and other types of compensation that are due to the advisor? Are there other type of revenue sources that are provided for by contract? What are the growth rates of this revenue over time? How is it performed? In addition to revenue, you're going to want to take a look at investment processes and policies. What are the characteristics of the portfolio? The number of investments, geographic and sector dispersion of investment, portfolio turnover, and embedded portfolio risks. In addition, you want to focus on the performance of the underlying portfolios. What has been the history, net of fees, the ability to replicate the positive investment performance going forward. In addition, you'll want to focus on the customer base of the target as well as its products. In addition to the business and financial aspects, a very key component of the due diligence process will be the legal, regulatory, and compliance areas. And this is the one that may bear the most time and ultimately create perhaps the most risk for you going forward. First of all, an area to look into is the organizational and ownership structure of the investment advisor. What is the composition of its capital and its investor base? Are there any strategic or unaffiliated investors in the picture? Does the investment advisor own any other business apart from the investment advisory business? Try to access the board meetings, investment committee meetings, and other advisory board meeting minutes as part of your diligence process. Critical to analyzing the legal and regulatory compliance risk are the underlying contracts that the investment advisor has. Review the investment advisory agreements and other revenue generating agreements. Explore the difficulty in transitioning customers to the new organization and other potential change of control issues as that might affect clients, investors, lenders, etc. Ask yourself the question, Are the fee arrangements of the target investment advisor fair, and are they fully disclosed? Are there most favored nation clauses in the picture? Are there side letters giving special rights to certain investors? Are there separate revenue sharing arrangements? What about clawback provisions requiring you to return profits at the conclusion of a fund or along the way? What about redemption terms? Will there be sufficient cash flow to satisfy those terms? Another key area, of course, is the registrations and license themselves. As an investment advisor, registered or unregistered, you'll had to have filled out a Form ADV, and you want to make sure that you had a chance to fully review all the components of that Form ADV, all the attachments and the schedules. Of particular attention, and again, this is keying off some of the areas that the SEC has seemed most focused on in recent years, is the identity, background, experience, and training of the Chief Compliance Officer. Custody of client asset issues is also a key focus for your due diligence. Investments performing reporting, advertising practices, and best execution practices should also be carefully looked into. Most recently, and you'll generally find that the SEC and its audit procedures will also be following events in the news. So over the last few years, there's been a heavy focus by the SEC on cybersecurity matters, and this affects both small and medium, exempt, and registered reporting advisors. They will attempt to verify the policies and procedures as well as your record keeping regarding your cybersecurity policy procedures. Even though you may not think as an advisor you present a systemic risk, the SEC is being very attentive to these issues. Most recently, the news about the Panama Papers matter will only increase the SEC's focus on the investment advisor's anti-money laundering policies, procedures, and record keeping. In addition to these items, and again, as I mentioned a couple times here, record keeping is of paramount importance. It's one thing for the investment advisor to have policies and procedures, but does it actually have documents to back up those policies and procedures on a regular and continuous contemporaneous basis? Are there legal proceedings in the picture that are pending and threatened? Are disclosures required of the financial statements, and were those properly disclosed? Can those legal proceedings be disclosed before the signing of the business combination? Are there any legal proceedings involving ultimate beneficial owners? Try to dive into any type of recent audit requests and regulatory examinations. Look at other types of SEC and state regulatory disclosures and communications. A key area to focus on are potential conflicts of interest, and you're going to spend some time focusing on current, planned, and even possible instances of dealings that clients may have with those who might deem to be affiliates. Again, this is a key area of review for the SEC in its audits, and you're going to want to make sure that those are clearly disclosed and clearly described, and adequate record keeping is kept about those kinds of relationships. In addition to all these items, you'll want to look at the supervisory structure of the investment advisor target, its management committee, who sits on those committees, what is their experience, what is their background, have there been any type of regulatory related claims or events against any of those individuals, what about personnel matters, the number of employees by function, the background and employment terms, have there been any key personnel departures, employee benefits, that may have either been recently removed or added in to the picture that may change the economics of the investment advisor. Finally, in addition to the business and financial due diligence, as well as the legal, regulatory, and compliance due diligence, you're going to want to focus on accounting and tax, review the books and records for compliance with SEC reporting requirements, review the financial statements, and probably most importantly is looking at system integration issues. How will the new combined business work together, both in terms of employees, but also in terms of technology and systems and reporting? All due diligence is, as I said at the outset, intended to help you determine finally, is this a business that I want to do? And if so, how do I structure the business? We recently structured a transaction for an advisor who had an offshore fund manager where one party bought that fund manager through a stock purchase agreement and separately bought a related sub-advisor business here in the United States through an asset purchase agreement because it had concerns about potential liabilities down at the U.S. level. I'm going to go ahead and turn this over now back to Lorenzo to talk a little bit about the specifics of the purchase agreement as part of the deal execution.
Thank you, Michael. So we're going to talk about transaction documentations, and the anecdote that you went through, I think, is a good segue, because the next topic is structuring a deal. Before the parties can paper a transaction, they must choose the proper structure. Although outside the scope of this presentation, tax considerations are critical in structure of any M&A transaction, and transactions involving advisors are no different. You then look at whether an outright purchase or a majority investment is contemplated. The latter may be easier to accomplish, but comes with the added complexity of governance arrangement that will need to be implemented to, for example, give seller minority protection rights and put in place appropriate exit mechanisms. If it's an outright purchase, is equity being purchased or assets, or a mix of both? Our own experiences vary. For example, most of the deals that I've been involved in, some of which involved publicly traded parties, were equity purchases, whereas Michael's experience has been mostly asset deals, or, as he mentioned, a mix of stock and assets. In terms of parties' preference, it's difficult to generalize and leaving aside tax considerations. The seller will typically prefer an equity purchase, so it doesn't have to deal with a legacy business, and it's easier for non-client third-party consents and other purposes if the legal entity stays intact. A buyer, on the other hand, may prefer an asset purchase, especially if it can't get comfortable with the target's liabilities or seller's willingness to stand behind those, so the buyer can pick and choose what target liabilities to assume. An asset purchase is the only way to go if the buyer is only interested in a portion of the seller's business. In an asset purchase, the seller is the entity itself, not the owners of the equity, although the owners would like to be added as guarantors to the purchase agreement. An asset sale may be more complicated than a stock purchase because of the need for non-client third-party consents and the fact that assets that the buyer is purchasing and liabilities the buyer is assuming need to be specifically identified and transferred. In a stock purchase, the sellers are the shareholders or members or partners of the entity being sold. So they will be direct parties to the purchase agreement and not just as guarantors. If there's too many of them and not everyone can sign up to a purchase agreement, a statutory merger structure may need to be used. In this case, the company itself and not the shareholders is a party to the merger agreement, but the shareholders will vote on the merger by written consent or at a meeting. It's worth noting that a merger may come with appraisal or dissenters' rights for those shareholders who do not vote in favor of the merger, or shareholders may and should be asked by the buyer to enter into voting agreement at the time the merger agreement is signed, so as to minimize the impact of those rights. Although perhaps not common in M&A transactions involving investment advisors, the purchase consideration may consist of acquired stock or a mix of cash and stock, more typically if the buyer is a publicly traded company. Using stock or other buyer securities as consideration raises issues of securities law to which both parties need to be sensitive, as they may significantly impact the timing of the transaction if a way around registering those securities with the SEC is not found. For example, if not all sellers are accredited by paying only cash consideration to the non-accredited sellers. Due to the uncertainty surrounding future performance and AUM levels after the closing, the purchase price is typically structured with a partial payment at the closing, and the remainder of the consideration, often a material portion, paid on a deferred basis 3 to 5 years out, contingent on the target meeting certain agreed milestone that may be tied to earnings, AUM levels, the retention of key clients, or a combination of those. An installment payment plan, which is essentially seller financing, may also be used, which may or may not be contingent upon the achievement of a milestone. Regardless of the mechanism used, the buyer will acquire title to 100% of the assets acquired at the closing, and the seller will only retain a contractual right to the payment of the remainder of the consideration payable after the closing. It's very common in our experience for a purchase agreement to provide for an escrow or a holdback as security for the seller's post-closing indemnification obligations, or to protect the buyer from an unfavorable post-closing price adjustment. What this means is that a portion of the purchase price payable at the closing to the seller is instead placed into escrow, which is administered by an independent third party, or held back by the buyer itself for disbursement after an agreed period, which generally matches the survival period of the seller's reps and warranties or the final adjustments of the purchase price. If the agreement contemplates an earn-out or an installment plan, those can also be used for this purpose in lieu or in addition to the escrow or the holdback, while giving the buyer a right to set off its right to indemnification from the seller against its obligation to pay additional consideration to the seller after the closing. If the purchase price payable at the closing was based on agreed amounts of working capital, revenue, or other financial metric, those metrics typically are reassessed at the closing by the seller and the price adjusted accordingly. Then they're finalized after the closing, typically within 90 to 120 days by the buyer, after the buyer has taken into account any objections raised by the seller. Depending on the deal structure, other adjustments may apply relating to target debt, target cash, and transaction expenses of the seller. We'll go to the next slide, seller's reps and warranties. I think we're all generally familiar with the purpose of reps and warranties. With respect to scope, though, in addition to the standard reps that you'll normally find in any purchase agreement, when investment advisor is being acquired, you also find reps and warranties that address the status of the target as an investment advisor, including as it relates to the advisor's registration under the Investment Advisors Act, or if applicable in any other state or other jurisdiction where the advisor conducts its business, Form ADV, compliance with the Act, the advisor not being disqualified along with its director's office and employees from acting as such under the Act, and having adopted policies and procedures, including a code of ethics, designed to assure compliance with the Act. Also, a rep and investment contracts do not require the affirmative consent of the client to assignment, and if private fund clients are involved, a rep that none of those funds is required to be registered and is an investment company under the Investment Company Act. Affiliate transaction representations are not unique to M&A transactions involving advisors, but they are especially important here given the heightened sensitivity to conflicts of interest, as Michael described earlier. Buyer may also make representations and warranties as noted if the buyer stock is involved as part of the consideration in the transaction. And if buyer is suspected to borrow to fund the acquisition, the seller may want a rep from the buyer that at the closing the buyer will have sufficient funds to close the transaction and pay all transaction expenses. Third-party insurance coverage for breaches of business reps and warranties has become increasingly popular in the last few years as an alternative or enhancement to the traditional rep and warranties and seller indemnification structure. So the parties should consider that. The parties typically negotiate who will pay the premium on such a policy, and at times the purchase price would be reduced in exchange for less escrow or less holdback, and therefore a higher cash amount payable to the seller at the closing. Next slide. Covenants that apply during the pendency of a transaction and are more typical in an investment advisor context relate to the seller's agreement to seek and obtain client consent to the transfer of the advisory contracts. Jack will discuss those. And also seller's agreement not to compete with the buyer or the target and not to solicit employees or customers of the buyer or the target for some period of time after the closing. There's also buyer's obligation to purchase professional liability runoff coverage to continue for a number of years after the closing, seller's coverage for pre-closing errors, omissions, and other negligence acts. If buyer is unwilling to foot this bill, the seller may be well advised to purchase this coverage on its own. Other covenants may be related to whether other regulated entities are involved, such as mutual funds or broker-dealers. The closing conditions will be the subject of Jack's discussion in the next slide. As to indemnification, we touched on this several times. Here, in addition, just noting that this is perhaps the most heavily negotiated provision of the agreement, I will mention that for liabilities identified during diligence, particularly those related to litigation or regulatory issues, the buyer may insist on a special indemnity that is unrelated to a breach of the representations of warranty by the seller and that lasts longer than the survival period applicable to the seller's representations of warranties. Jack will now walk us through the end of the presentation, discussing closing conditions, regulatory approvals, and ancillary agreements. Jack?
Thank you, Lorenzo. So as Lorenzo discussed in the purchase agreement, there would typically be covenants. A number of those would be tied to closing conditions. One of the larger ones is going to be regarding client consent to assignment of the advisory contract. And these types of consents are something you're going to want to identify early on because they're going to help determine the timing of the closing. So for registered investment advisors, the Investment Advisor Act actually provides that any investment advisory contract should include a provision that the investment advisor may not assign the contract without the consent of the client. The mechanics of obtaining that consent, however, are not prescribed by the regulations. However, it's important, whether the investment advisor is registered or not, to actually review the actual terms of the advisory contract, see whether it includes any affirmative consent requirements, see what the mechanics are. And in fact, even if the agreement may be silent on that point, given the fact that clients would typically have a right to terminate their investment advisor relationship, you should really discuss how best to handle the migration of those customers. And the consent obligation will obviously feed into another very important closing condition, which is going to be the minimum assets under management. And the successful assignment of these advisory contracts obviously would help achieve that closing condition, failure of which could result in a price reduction, which is obviously something that the seller would want to avoid. If in cases where there's a registered investment advisor and the agreement is actually silent on the mechanics of obtaining consent, the SEC has endorsed a process where negative consent can be provided. And it's basically a two-step process in which you would first send out a notice notifying the investors of the proposed transaction. And then in a situation where they didn't reply, you would then send out a second notice letting them know that their accounts would continue to be managed under the new investment manager. Failure to obtain consent, as I mentioned, would be potential cause for the transaction not to go forward, could result in price reductions, which again would be something that the parties would want to avoid, and might also be something that would be tied into some of the indemnities that Lorenzo talked about, where the seller would make representations regarding consents, and if there were a misrepresentation, for example, if it had improperly obtained consent or not followed proper protocol, there could be potential liability. And so there, for breach of misrepresentation, you'd want to make sure the indemnities cover that. With respect to private fund clients, there's some special consideration would have to be paid. You'd want to review the offering documents. You'd want to review the partnership or management agreement pursuant to which the investors have signed on. And again, see what the terms provide as far as requirement for consent and mechanics for providing consent. And there's a potential conflict that you would want to avoid, which is that typically if it were a partnership or LLC, the general partner or managing member, in fact, could be an affiliate of the investment manager that's being sold, or in fact the same party. And as I mentioned, that would clearly provide some form of conflict, and so you'd need to discuss how best to avoid that conflict and again, achieve migration of the fund and the investors therein. Moving on to regulatory approvals, that is really going to depend on the facts and circumstances and guidance available from the different agencies at that time. Currently, with respect to the SEC, no approval per se is required with respect to a change of control in the investment advisor, so that's helpful. But you need to review if the acquisition contemplates additional regulated entities that may be affiliates of the target. So in case where there is, for example, an affiliated broker-dealer, if a broker-dealer is involved in the transaction, a continuing membership application that will be filed with FINRA. Approval could take up to 6 months. However, there is a process by which, if the application is filed and no objection by FINRA comes within 30 days, then the parties could decide to close. However, again, there's always the potential risk that something could come up down the line. In the case of an investment advisor that's an advisor to a mutual fund, there the Investment Company Act would provide that assignment would result in an automatic termination of the management agreement. So there you would now need to go through the process of getting both the independent board of directors of that particular mutual fund, as well as the shareholders to consent to the new assignment. Finally, the investment manager could be exempt or could be registered with the CFTC under the Commodity Exchange Act as either a commodity trading advisor, commodity pool operator, futures commission merchant. And so as well there, you would need to take a look at the different filings, determine whether the exemptions still apply, determine whether registration may now be required due to loss of an exemption. So that would all have to be analyzed. As I mentioned, even if no regulatory approval is required, you would still have to go through the regulatory filings and determine which ones would require updates, and the majority of them will. With respect to the investment advisor, the Form ADV would have to be updated both at the execution of a definitive agreement as well as promptly following the closing. Form PF, which is a new form that needs to be filed for registered investment advisors managing private funds in excess of $150 million under management with respect to those funds. Again, you'd need to determine whether that Form PF needs to be updated, or as a result of the acquisition, you may now exceed the thresholds and you may now actually need to file. And one point I just want to make back on the regulatory approvals is, as with any M&A transaction, depending on the size, the requirements under Hart-Scott-Rodino are also going to have to be examined and determined. Finally, for broker-dealers, you take a look at the Form D and determine whether updates are required, and then registration statements for any mutual funds. I'm conscious of the time. I want to make sure we leave time for a few questions. I'll just quickly run through some of the ancillary agreements, some of which Lorenzo had mentioned. Governance arrangements in situations where the seller may retain a minority interest. That's something you'd want to negotiate. Typically, these ancillary agreements would be signed at the time that you execute the purchase agreement, and then would be effective at closing. So in the instance where a seller retains a minority interest, they're going to want to make sure they have certain veto rights, put rights, tag-along rights, depending on what happens to the new entity. The buyer may want some kind of exit strategy, so an ability to buy 100% of control or cash out the seller at some point down the line. And then management arrangements are also going to be critical. Oftentimes, key managers will remain to manage the new entity. And the key to a successful acquisition is going to be providing them with some form of incentive. This would typically be negotiated at the time you're talking about the purchase price. Could come in the form of earnouts, performance bonuses, or equity incentives. And another point to remember in terms of management arrangements is there may also be non-core but valuable employees who have historical knowledge of the business that you also would want to come along, and you would put in place employment agreements with those parties as well. And then finally, non-competition and non-solicitation agreements with the seller. So these would typically be in the purchase agreement, but to the extent that any employees do come on as employees of the new entity, you would put in place an employment agreement that would contain additional non-compete and non-solicitation provisions, and those could go on for a certain period of time following either employment or, in the case of the purchase agreement, following closing. And then just the last point I'd like to mention is that sometimes the seller, and this is just something to be aware of, which obviously makes sense, is the seller may require certain agreements from the buyer to also agree to a non-solicitation covenant during the pendency of the transaction to protect the seller from the buyer poaching customers if the sale ends up going through. So in order to leave some time for questions, this concludes our presentation. We certainly hope you found this overview informative. And Phil, I'll turn it over to you now for a couple of questions.
Thanks, Jack, and also Lorenzo and Michael as well. Yeah, we are right up against the time crunch, but I do have one question that seems to have come up a number of times throughout the registration form, if we could get through that quickly. So can an RIA that is affiliated with a broker-dealer be permitted to enter into a purchase agreement with another RIA that is affiliated with a different broker-dealer?
Phil, it's Michael here. I can take a shot at that one. I think the two RIAs would be permitted to enter into a purchase agreement under those circumstances. But as we said, while we discussed diligence and conflicts earlier during the presentation, all registered investment advisor affiliations on the buyer and seller side need to be mapped out at the outset. then the impact of the transaction on those relationships must be reviewed for potential and possible conflicts, such as commitments to use one of the affiliated broker-dealers following the acquisition, so that the appropriate disclosures are made and, if necessary, any client consents are obtained.
Great, thank you. And did anybody else want to add to that?
No, I mean, we agree that it's really sort of something that need to be analyzed, so nope.
Okay. Well, great. Yeah, I apologize that we are at the end of the call here, but Lorenzo, Jack, and Michael, on behalf of the entire Succession Link community, I certainly want to thank you for all of your time and valuable insight. And given the fact that there are so many questions that have come in, I definitely see a part 2, if you're willing to maybe expand on some of the topics that we brought up here today.
It'd be our pleasure, a pleasure to be here and to do this with you guys.
Great.
Thank you very much.
And for all attendees, thanks for joining the webinar today and for your continued support of the platform. That will conclude today's webinar. Until next time, everyone, thank you for joining.
Thank you.
Thank you.